All right, welcome back. As Dr. Demi indicated at the outset of this morning's session, we're considering religion and culture in two aspects. One is in terms of our ability to understand and relate to cultures different than our own, and the importance of getting that right in terms of mission accomplishment and understanding the environment where we operate. We'll return to that subject again at the last session today when Dr. Jessica Stern, who's one of the true experts on religious terrorism, will speak to us about how religious terrorists think. The next two sessions, however, will deal with this internal question about the proper understanding of how to balance personal religious convictions and appropriate constitutional service internal to U.S. military forces. And so we're privileged to have as our speaker today one of the two authors of what I consider to be the definitive article on law review article on this question. By law review article, I mean Linell and her colleague Fitzke reviewed every case litigated involving religious practice and constitutional responsibility in the history of the United States. So she is one of the true experts on this question. Linell is the Deputy Chief of the Air Force's Military Personnel Litigation Branch in Arlington, Virginia, where she defends the Air Force in an array of federal civil litigations involving military personnel and constitutional law issues. Major Letendre is a graduate of the United States Air Force Academy and the University of Washington's Law School. She and I were colleagues at the Air Force Academy for a period of time, and we welcome Major Letendre.
Thank you. Well, I'm going to begin in true lawyer fashion, and that is with the fine print. Everything I'm going to say today is my own views, my own personal opinion, and I do not represent either what the Air Force or the Department of Defense thinks about these matters, as will or may become clear as I go through my presentation. I do hope that that is included on all the tapes as well, Martin. Otherwise, I may not see the next rank. Hopeless disarray. It is my hope that at the conclusion of my remarks today that will not be what you were thinking about the presentation, but instead that is what Justice Thomas, one of our Supreme Court justices, has said about Supreme Court jurisprudence in the area of religion and our religious clauses. So if the Supreme Court is so confused, how are we going to make sense of it? Well, it starts pretty easy, right? I mean, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Why is that so complex? Why do we have such a hard time understanding how we take these simple words and apply it to what we do? Well, I know my audience, and I know that these two clauses cause tension. I'm hoping that one of you could tell me a little bit about the Scylla and the Charybdis. I know there's some seafarer out there somewhere who also studied Greek mythology. No one? Because we're going to talk, oh good, we have an old-time seafarer. Sir, what's the Scylla and the Charybdis? And so we had two Greek mythological creatures, one on the cliff and one in the ocean, and the seafarers had to choose which one to try to go through because there was this narrow passageway. And yes, ladies and gentlemen, this is where we got the phrase between a rock and a hard place. And this is also what the Supreme Court Justice Rehnquist has said, is that the court is constantly narrowing the channel, and that is the channel that we have between the Free Exercise Clause and the Establishment Clause, and we're supposed to make our way through this. And that's what Dr. Martin asked me to come and talk about, what Dr. Cook asked me to come talk about today. But some of us might say, well, isn't this old news? Here is a picture of the building on the best military academy in the world. Steve told me that I should say that, right, Steve? And aren't these issues old news? I mean, it was years ago. It was when I was teaching, 2004, that all these happened. We don't have problems now. It hasn't come up of late, or has it? Just over a year ago, there was a Jewish private who was beaten. He was beaten because of his religion. Or at the beginning of last month, beginning of this year, we made positive news at the Air Force Academy. We actually established a rock circle for pagan worship, for Wiccan worship, on a hill above the chapel. And we were heralded by great strides that the Air Force Academy is making in free exercise. Well, that was until I got an article this morning that was published in the LA Times that not 2 weeks after this circle was dedicated, there was a cross that was put on the circle. That's essentially like graffitiing a swastika on a Jewish temple. Or what about this, which has already been mentioned today, the flack that the Department of Defense has had over our rifle sights that are being used in Iraq and Afghanistan that have inscriptions to chapters and verses in the New Testament, and us having to defend against the idea that we're really on a Christian crusade. I believe that these are important issues for us to take a look at, and I'm hoping that I fulfill what I've been asked to do. Number one, that we walk through what these constitutional tests are. I promise I am not trying to make you an expert in the law, because I like it when you call me. I like being needed, and so I don't want to write myself out of the military. But at the same time, it is helpful for us to understand what these rules are. And so I'm going to lay out a summary of the constitutional tests, and then I'm going to walk through one such practical example, that being prayer and solemn military events, to show you how one might go about evaluating whether or not our practices are in compliance with the Constitution. And then it's going to be your turn, because we're going to walk through some other practical events. And so far, we haven't had a lot of discussion, and it's my goal today to start. So we're going to walk through prayer at routine military events, and I want to know what you think, as well as religious speech and accommodation. The point of walking through these practical exercises is not to find the right answer, but instead, since we are at an ethics conference, is to ask why. Why might we have these rules? Why might we have this tension? And given that, are we following them? And if not, is it okay? There's not necessarily a right or a wrong answer, and that's what makes my job so much fun. The Establishment Clause. So we have these two boundaries. One is the Establishment Clause. How do I know if I'm in Establishment Clause land? Well, if it looks like the government is trying to do something that's benefiting or promoting religion, then I'm more on the establishment side of the house. And I need to understand a variety of tests that the Supreme Court has laid out. But this is the overarching one, and one that is often misunderstood. The prohibition is not against the government choosing favorites between religion. The prohibition in the Constitution is for the government to choose or to favor religion versus non-religion. I often hear, well, but I'm just going to give a non-sectarian prayer. I'll just pray to some generic God, and then it's okay, right, Linell? Not really. Under Establishment Clause principles, it's religion versus non-religion. And with that, let's take a look at what some of those tests that the Supreme Court has come up with. The main test came from a case called Lemon. And in it, we had Rhode Island, actually, was one of the states that was trying to give money. They had a problem with some education. And there are private schools, the kids got educated at a much higher level than at public schools. Why? Because they paid more money to the teachers. And if you're coming out of college and you want a good paying job, you went to the private schools. I know I talked to one of you last night who was educated in a Catholic school, and I'm going to pick on you. So where are you? Raise your hand. Now I'm going to find you. And so the idea was, well, we're going to set some, Rhode Island said, we're just going to even it out. And private schools, parochial schools, if you pay your teachers this amount, we're going to help you pay those teachers. But they knew about this whole Establishment Clause issues, and they said, all right, we don't want to get into your having money go towards religion, so those teachers, we want to take a look at the books, we want to take a look at, and make sure that in that math class that they're not talking about religion at all. So we're going to come in and take a look at what you're doing, just to make sure that our money isn't being used for religious purposes. The idea was to try to even out and cap out what teachers are getting made, and so that the schools had more equal and balanced education. So this got all the way to the Supreme Court of, is this okay or is this not? And the Supreme Court came up with a three-part test. And the first is, well, what's the purpose? Why were they trying to do this? Hand. Why were they trying to do this? What was the purpose? Was it secular? Did it have, sir? To level the playing field. Is that a religious reason? Absolutely not. And the Supreme Court said, you're good there. That's number one. It had a secular purpose. You're okay. And then the second test was, what was the effect? Not just any effect, but what's the primary effect? Was the primary effect here to increase or promote religion, or to inhibit religion in a way? And the Supreme Court did what we do when it's fourth and long. They punted. Okay, because they didn't want to answer this question. This was too hard because there was an easier one, and it was a three-factor test, and they went to this one, which was entanglement. Is the government entanglement with religion too excessive? And this is where, raise your hand if you went to Catholic school growing up. There we go. And this is when they were going to go in, and they were going to be the ones to take the rulers and slap the nuns on the knuckles and say, no, you aren't allowed to teach religion in math class, or you're not allowed to teach religion in this class or that, and I want to approve your textbooks. And the Supreme Court said, that's getting the state and the government way too involved in the details of religion. That's excessive entanglement, and that is not allowed. And that, ladies and gentlemen, is the lemon test. And when we get to the question and answer, you can easily remember it because it's peel. Purpose, effect, entanglement, lemon. So there's a couple more tests that you can throw out when we get to the scenarios. The first is endorsement. And the idea of endorsement states that if I'm looking at what the government is doing, does it look to a reasonable observer? And this is a smart, reasonable observer. This is a reasonable observer who understands the history of what you're doing. It's a reasonable observer who understands all the factors that went into the decision-making process. And would that person look at this situation and believe that the government is endorsing religion? And if so, it violates the endorsement test and thereby violates the Establishment Clause. Another way that courts have looked at this is the idea of the coercion test. And principally, courts have looked and used the coercion test for children, for secondary schools, looking at prayer at schools, prayer and graduation, etc. And the idea is the government coercing someone to participate in a religious exercise? Now, I did say school children. Do I have any VMI grads? Not a one. Well, they did use it in a VMI case, not the Supreme Court, but a court of appeals, when they threw out the noontime prayer and the evening prayer at VMI, under the idea that rats at VMI were being coerced into a religious exercise. Remember that when we get to the scenarios, that may come in useful. So that's the Establishment Clause. On the other side, there's this idea of free exercise. And we know that we're in free exercise land if it looks as if the government action is burdening religion. If we're doing something to hamper someone's ability to exercise or believe how they choose. The court looks at this in one of two ways. First, they look to see, was the law directly aimed at religion? And the courts say that these are easy to recognize, and they're also pretty easy to decide. Because if the government is making a law with the purpose of hampering religion, and that's its aim, then they're almost always struck down. But most of the time, our lawmakers are a lot smarter than that, and there's some other reason that they're trying to, or purpose for a rule that might be affecting someone's free exercise. And that's a religious neutral law. In the 90s, the issue came up was the use of peyote. And there was a law that said that, well, all of these types of drugs are illegal. One of them might be peyote. And that greatly impacted an ability for Native Americans to participate Native Americans to participate in some of their religious exercises. And the government upheld that, or the Supreme Court upheld that and said, that's okay, because that wasn't the purpose of the law. It might have had that effect, but there was a rational basis. There was a logical reason that the government was trying to enforce, that of restricting drug use in the United States. And so the Supreme Court said that was okay, and actually said that all it had to meet was the idea of minimum scrutiny. And those are almost always upheld. Well, Congress didn't like that answer so much. They didn't like the idea that as long as the government had a law that was neutral toward religion, that otherwise affected religion, that it could be so easily upheld. And so the Congress passed the Religious Freedom Restoration Act. And why is this important to us? Because it affects us in the federal government. It's been struck down as it applies to states. But guess what? We are here because we are part of the federal government. And it applies and has been upheld by the federal government. And what the Religious Freedom Restoration Act states is that if we are to place a substantial burden on a sincere religious exercise, then we have to go up to this strict scrutiny. We have to have a really good reason for doing it. And we also have to make it as narrow as possible to accomplish that means. Let's put this in some practical terms, and we'll get to this when we talk about accommodation. But if one of our troops has a sincere religious belief, and we're going to prevent them from doing that because we want to have an inspection, we have to have a compelling government interest to restrict that ability. Otherwise, we're supposed to accommodate. So we'll talk about some of those scenarios as we go through. But this is the idea of free exercise of religion. And I wish that that was all the guidance that you had to worry about. But we have op-jag opinions in the Air Force talking about prayer at staff meetings. And if you're in the Air Force, you had the first set of religious guidelines. And then you had the revised set of religious guidelines. And then you had the thing from Congress that said you need to stop issuing all these. By the way, this is still valid. And if you want more of that history, I'm happy to explain it to you in either Q&A or afterward. So we've got all this guidance. Well, thanks for all of these rules, but let's get to some practical realities. How do we apply this? How do we make sense of everyday issues? And I'm going to start with the idea of prayer at solemn military events and give you an example of how one might walk one's way through these different rules. So let's set the stage. Graduations, dining outs, promotions, change of command, all formal, solemn military events. Raise your hand if you've heard a prayer at one or all of these. If you didn't raise your hand, you were either asleep at those formal presentations or you are asleep now. Today, I want to challenge for a moment our assumption that these are legal. I'd like to illustrate for you some of the hurdles based on the tests that we've just discussed about supporting these and defending these. Now, if you listened when Martin introduced me, you heard that my job right now in the Air Force is to defend the Air Force from lawsuits like this. And I guarantee you that I can defend the Air Force from lawsuits against this. That said, let's go to a theoretical discussion about if push came to shove, could we? And what are some of the arguments that we're going to be up against? And the basis for walking through this is that if the constitutionality of prayer at these events is questionable, why? Why? Not why do we continue to have the prayer, but can we make some sort of sense about the ethical underpinnings of the tension in these free exercise and establishment clauses? Can we make some sense as to why we have these rules that might cause them to be questionable? Because it is answering that question that is not just important to us as a military, but I would assert is important to us as mid-grade and future senior leaders of our respective services. It's important to us before we take command. And it is important for us operationally. And I hope we can touch upon those whys as we go through. So let's take a look and get below the surface on whether or not we can defend prayer at solemn military events. The Supreme Court had a tough case called Marsh versus Chambers, and they had a state legislative prayer in Nebraska, actually, that came to them. And they had this lemon test. What's the lemon test? What are you supposed to remember? Peel. Okay, and they said, all right, prayer. Purpose, what do you think? Secular? No, really hard to make prayer secular. And so the Supreme Court decided, we're not going to use lemon. It's too sour. I have to come up with something else. And so the Supreme Court said, all right, let's take a look at history. And they looked, and literally the week that our founding fathers ratified and discussed the First Amendment, guess what else was on the legislative agenda that week? Paid chaplains. And the Supreme Court said, okay, our founding fathers, they're not crazy. They couldn't have said and passed the Establishment Clause on the same week that they did the chaplain issue and said that those were in conflict. So there must be something else here. And so they came up with this, the deeply embedded historical exception. That there must be some things in our history that were not meant to be in violation of the Establishment Clause. And I will tell you that the military has grabbed hold of this exception because I see it in those interim guidances that the Air Force had, because they talk about the deeply rooted exceptions to some prayer in our 60 years of history. See, I can make fun of ourselves. But here's the problem with the deeply rooted exception. It's that both in Marsh, the decision itself, and also in later Supreme Court cases, they have limited this exception. They've never expanded it. And they've limited it to specific practices that were in place at the time of our Constitution. Thus, since we did not have public schools at the time of the Constitution, you can't use this exception to support prayer in public schools. So that starts to beg the question. The issue for the military is, do we have to show specific evidence of prayer? Or is it enough that we had a specific event that's gone on over time? Or is it enough to show that we have had chaplains for as long as we've been in existence? If it's the former, if it's the chaplains leading troops in prayer, well, we've done that. There's lots of examples of that. But if we have to show specifics at specific events that we've always had prayer, we're in trouble. Actually, you Navy folks are probably in better shape than the rest of the services. Take this, for example. You Navy folks, for your dining ins and dining outs, you date those historically back to the Revolutionary War. Where are my Army brethren? I know there's some of you, yes? You all say that you didn't start dining ins until World War I, maybe World War II, and then my Air Force folks, we didn't start them until after World War II. And so we're in trouble if we have to date it back to a specific event and time. There's a couple other reasons that we should be a little leery of over-reliance on deeply embedded or historical practices. One is that the court has rejected a rule that all accepted practices that are 200 years old are constitutional today. And here's the other one that gives me the greatest pause. The court's never, ever used marsh again. That's going to be tough. And if that's the only thing we have to hang our hat on, the justification for military prayer becomes substantially more difficult. Let's walk through some of those other tests. Well, does it pass the Lemon analysis? I see some shaking of heads. Well, some arguments are, well, we're not giving the prayer, the purpose of the prayer is not a religious one. The purpose of the prayer is just to heighten solemnity. That's hard. It's hard because we have a lot of other things in our formal functions that heighten solemnity. This is one of them. The uniform, the posting of our colors, having formal speeches. We do lots of things that make our ceremonies formal. And so our reliance on, well, prayer just adds an extra degree of solemnity might be pretty tough. Another idea is, well, this is just private speech. And there's been a number of lower court decisions that have upheld graduation prayer. And essentially schools, high schools have gotten around it like this. The senior class, they can all vote on someone to be their representative. And then that representative gets to say something at graduation. We don't care what they say. We don't care, they've got a set amount of time. They can talk about the environment. They could give a prayer. So whatever they want to talk about is just fine. Because it's private speech at that point. It's not government speech. You want to see some problems that we might have in the military? Number one, we don't tend to put things to a vote. Number two, we don't tend to say you can talk about whatever you'd like to. You're here, chaplain, or you're here, other officer appointed to lead the prayer at an official function, to give the prayer or the invocation. So the idea that this is private speech becomes more challenging in the military. And if we don't have these, we're back to having a non-secular purpose for our prayer, the primary effect of which is to endorse religion. And there's at least some amount of entanglement, one could argue, if it's the commanding officer who's selected the person to give the prayer, the commanding officer who decided to have the prayer in the first place. But let's say we could get over Lemon. We now have a couple other remaining tests. One, we talked about that coercion, and Justice Black said that when the power, prestige, and financial support of the government is placed behind particular religious beliefs, the indirect, coercive pressure upon religious minorities to conform to the prevailing, officially approved religion is plain. We ask people to stand. We ask people to be quiet. Is it coercive? Well, one could argue that we're not school children. We can decide and think for ourselves. But then again, we are responsible for 18-year-olds, and how much freedom of thought do we give them at various, I think the answer is it depends at various times. And this is the argument that overturned the VMI evening meal prayer. The final hurdle we'd have to get over is that of endorsement. And I would say that this is very fact-dependent. I've been to promotion ceremonies where an individual who was being promoted introduced someone who was like her second dad. He's also a preacher. And he came up and gave the prayer, and he blessed her and her family and the great contributions that she was making to the Air Force. And there wasn't a person in the room who thought that that was government speech. And that's okay. There wasn't, with understanding the facts and the context of that situation, no one thought that the government was endorsing what that individual had to say. That was someone's private, personal thoughts. I've also been changes of command that had a very different flavor to it when prayer was involved. And so these are tough questions. And that's the analysis for solemn military events. Let's see, we'll put up both at the same time. And now we get to hear from you. All right, what's the slide on the left? Where am I? King Hall. What's King Hall for those of us who did not go to the Naval Academy? It's the dining hall. It's like Mitch's for you Air Force folks, all right? That's the dining hall. And give me Naval Academy grads in the room. What do you do before prayer? What do you do before lunch? Pray. Who? Explain.
During my time in 92 to 96, we would pray before every meal, or they would ask you to bow your heads and join them in prayer before breakfast, lunch.
Okay. Someone pick a test. You can peel the lemon. You can do endorsement. You can do coercion. Sir? Deeply embedded in military history. Might get us off. Okay, and why do you say that? Okay. We've been around forever. We can do it. Okay, and where are my really old academy graduates? Not old, excuse me, our founders, our seasoned academy. Do I have any of those? Who went to the academy in this, anybody go in the 60s or 50s? Anybody go when chapel attendance was required? It used to be. And then in the best form of sister service, getting along together, cadets from all, and middies from all 3 service academies sued, and they overturned compulsory chapel. And the deeply embedded exception didn't work because they'd always been forced to go to chapel. It was character development. All right, so if I'm not going to let you do that one, someone argue another one for me. How are you going to keep prayer in King Hall? Okay, so, and maybe that might fall into the coercive nature. It's not coercive. We rotate between religions. You know, we don't pick and choose. Now I get to play devil's advocate because I like the point. What am I going to say? What if you're atheist? And, oh, by the way, that the Supreme Court said it's not about picking and choosing between different religions. It's about what? Religion versus non-religion. Although, believe me, I would make that argument if I was defending King Hall. All right, and then I put the picture up on the right. Do you want to know what that is? Yes, the USS Comfort. It was sailing down to Haiti, and I was listening to the NPR, and they were talking about all the plans and the loading up, and they're setting sail for Haiti. And you know, at the end of NPR, National Public Radio, for those of you who don't listen to, they give like the sights and sounds, and they just let you listen to what's going on. In this case, it wasn't birds chirping in Grand Canyon; it was, you know, the ship. And it ended with the captain of the ship leading everyone in prayer. I almost drove off the road. And then I almost dropped my wine glass last night because I was talking to Admiral Wisecup, and I was telling him about this. And what did he tell me? You do it on every ship. So defend it. I know you're going to tell me what? Defend it. What are you going to say? It's not mandatory. Okay, so it's not coercive. What happens to the movie? I learned a lot last night talking to the Admiral.
Well,
They pause it. Are you allowed to talk? Okay, all right, so you don't have to listen to the captain.
The anti-God group are so fanatical, aren't they a religion unto themselves?
Potentially, sir. Can we say that it's not coercive? Okay, maybe I can get around the non-coercive. Maybe I can say you're not required to listen. What about endorsement? How do I get around endorsement?
position moving forward?
Absolutely. Okay. So I have my junior guy, and I force my junior guy to get up and lead the parade. But no, your point is very well taken. I think that's better when it's not the captain, or in some cases, I've been told it's the chaplain, or it's the junior folks, and we're switching between religion. I promise you that I'm not here to kill evening prayer on your ships. But why might we have those rules? That's, I hope, is a question that you talk about at your seminars today. Not to have the end of historic Navy traditions, but to ask, why might I be questioning whether or not we could really defend it? Why might there be rules that would say that we shouldn't? At routine military events, I would argue we have a harder time. The Navy might have the rare exception of saying that we've always had evening prayer on ships and that we can sustain it in deeply rooted. But I will tell you that we haven't always had prayer at staff meetings. I probably won't be able to defend that. There's not the same solemnity argument that we had at those formal functions. I would assert that we'll likely fail the endorsement test and we'll have a real hard time on the coercion, although you brought up some really good examples about how we could lessen that effect. And maybe those are some of the examples that you should think about when you go out to command that ship. What can I do to make this a less coercive environment, to make it seem less like we're endorsing? And then you can just ignore them. And that's actually what's happened in the King Hall case. The ACLU has sent numerous letters to, in this case it was to Vice Admiral Fowler, about the Naval Academy's tradition of prayer, of noontime prayer. And the Navy's basically ignored them. At the Air Force Academy, we have a moment of silence, and you can think about your test or whatever else you wanted to think about that day. All right, now I get to go walk again. Now we're going to apply these same types of ideas to religious speech. Let's get it out of prayer. Can this soldier do that? Why? He's tired. Okay. All right. Well, let's assume for a moment that he's having some sort of religious contemplation. Can he do that? Why? Well, why not? Why? He's not affecting anyone else. And is he constitutionally have a right to do this? Absolutely. What was that other phrase that we talked about? Free exercise. Right? I like the Establishment Clause, but we do have the right to do this. What about this? What if I talk to my buddies? What if I encourage my buddies to participate in prayer, or just talk about religion, or have a Bible study? Can I do that? If I'm not on authoritative power, if it's voluntary, what else? I probably shouldn't give him a direct order to do it. All of those are really good points, and that gets us to the context of what we're talking about. Who's read this fabulous book? If you haven't, I highly recommend it. It's by Lieutenant Donovan Campbell. He led a Marine platoon in Afghanistan and Iraq. He's led them in both places. This was about his Iraqi tour. He's out now, and he wrote this book as part of his Harvard Business School thesis. I will tell you, it's one of the best love stories you will ever read. That said, go read it, it's a really quick read. But Lieutenant Campbell led his platoon, and before every mission, before every time they went out, they all said this 23rd Psalm together. And he credits that. He credits that to his unit cohesion. He credits that to his men being willing to work together and face fear and risk their lives together. It was their tradition. Is it okay? I'm seeing some heads go, yes. Why? I'm seeing some heads go, no. Why? Okay, common sense to build some camaraderie together. Does anyone disagree? Sure. Okay, I can argue it's a text. In fact, I've learned that there's actually the Marine version of the 23rd Psalm, Where are my Marines? And it literally reads like, go Google it, it's interesting. These are tough. These are really tough questions. Donovan Campbell, and I've had the great opportunity to meet him and hear him speak, but he's even talked about, he didn't know what the religious background of all of his folks were, but he knew it was important to his unit. He knew it was important to good order and discipline. Oops. Oh, back. There we go. So what about this? These are the gun sights that we've talked about a couple times today. John, chapter 8, verse 12. Is there a problem with free exercise here? Someone's shaking their heads no. Why?
Overreach. Private company.
Good.
Overreach, making something that may or may not be there to prove a point.
Okay. The first, it's a private company, and the Establishment Clause has nothing to do with them. Now, if there was a government contracting officer involved, that may be a different story, but they're putting this in their serial numbers from a constitutional point of view, was not prohibited. What are some of the problems that we've seen as a result? And this is where we might get into some of the operational issues. How? And then when the newspapers, when Al Jazeera is talking about this, and then they recount how, well, every time President Bush got an intelligence brief, what did it have on the front? A Bible verse. So when we look at religious speech, it's not easy. And I'm not here to give you yes or no answers. What I do think that we can learn from looking at the case law are some factors, and you all inherently came up with them because you told me when going through some of those examples, well, it depends on who's talking. It depends on who's listening. And it depends on the context and the characteristic of the speech itself. And I think it is an encapsulation of all of those that help us to figure out, are we doing the right thing? After all the issues at the Air Force Academy, we had the opportunity to go about and give briefings called Respecting the Spiritual Values of All Persons, RSVP, because we always have to have an acronym. And during that, we had to give it to all the cadets, all of the permanent party, civilians, military, contractors, and someone raised their hand with the, I'm gonna get you, Captain, because I was a captain at the time. And they said, so are you telling me that the Bible that sits in the 4 Stars office, who's the commander of Space Command right across town, that he's doing something wrong? And I gave a great lawyer answer of, it depends. It depends on where's the Bible. Which way is the Bible facing? How is he using it? If it's on his desk and it's facing him and he pulls it out when he needs help, then it's his speech. It's his freedom of expression. If instead that Bible is placed on a table between 2 individuals, and that's where he always goes to go sit down to talk to somebody, especially when they're in trouble, and the Bible isn't ever facing him, it's always facing the seat where the other person sits, that might not pass constitutional muster. it depends on context, it depends on who your speaker is, and the higher you get in rank and grade, the more this is going to apply to you. The more that we have to put our personal beliefs in balance with what our mission is. So let's move to what might be an easier topic, displays. What can we put out and what can we not? Well, the idea of displays can kind of be broken along the same lines that we did speech, formal speech, informal speech. Where is the display? The Supreme Court has helped us tremendously in this regard. In the top left-hand corner, there's a creche that was not okay, but there's a creche in the other top right-hand, but it's with a menorah and a Christmas tree, and that was okay, and that's the same case. Down here, this is the 10 Commandments. That was not okay there, but the 10 Commandments over here, it is okay. This is what we're talking about, the hopeless disarray of Establishment Clause jurisprudence. This is tough because the Supreme Court has a tough time figuring it out. But here's the one practical, because I did say that I'd try to give you some practical tips. This is what we affectionately call the reindeer rule. If you sprinkle enough in, you're going to be okay. And I don't mean that, but there's actually, if we peel back that a little bit and try to understand, well, why? Why, if all of a sudden, instead of it just being a singular religious display, it is to highlight the diversity of our individuals in service and how they practice? I'm reminded, because my daughter has learned, we live in Northern Virginia, and I live where there's all sorts of embassy people. It's the best education my daughter's ever had. And she's sick. She's 7 now. Last year when she was sick, she came back. It was in December, and they were studying all sorts of faith groups and how they each practiced. And she came home, and she's decided that she wanted to be Jewish. And she wanted to be Jewish because they got presents, not on one day, but on 8. Okay? But if we are talking about faiths in a diverse setting, and we're showing their symbology and what's important to them, and learning about the culture that Paulette talked about, that's okay. Not only is it okay, it's probably good for us. It's good for us to understand not just where we as the United States military is coming from, because I will tell you we have a lot more religious faith groups than one might expect, but also from a world perspective. And so while I might call it the reindeer rule tongue-in-cheek, it's probably some pretty sound rationale that's behind it. Well, what about in private areas? All right, you're now a base commander, you're a post commander, and you're driving through base housing, and someone's got a creche up. What are you going to do? Safety violation. Actually, at the Air Force Academy, some cadets had a menorah, and they were lighting it, and what did they make them do? It was a fire hazard. They since went back and decided that maybe we could figure out a way to make it safe and still allow people to practice. But is this a problem on base housing? Excellent. Say it louder, sir. It depends. Why might it depend? Why? Who's the audience and who's listening? Okay. So I'm walking through and it's just random base house, random O3, random E5. Problem? What if it's... Okay. What's the purpose? I'm promoting my faith group. I live in base housing, and I am promoting my faith group. Is that okay? Okay. So am I establishing religion? I hear no. Why? Sir?
In a way, they're practicing religion, and anyone else is free to do the same thing at their house. So they can do nothing, or they can do something different, but everyone's free to do it.
Good. You know, I don't think that on base housing, yes, we could make an argument or look at, are we establishing religion. But the Supreme Court's also said that we don't just check all of our constitutional rights when we put on the uniform, and not all of them. We do check some of them, but not all of them. And if I want to exercise or display my religious beliefs in my base house, that's my free exercise right. How about the wing commander? Is he or she different? Some say no. Why do you say no? Okay.
Do they lose exercise rights once they gain in rank, though? Is there a sliding scale?
Okay. Do I lose rights as I get more rank and grade?
It's public or military property, but is there an assumption of privacy?
There is, especially in base housing. I would argue that you have some amount of privacy. I do think it's more challenging with the wing commander. Yes, sir?
One of the problems may not be intent, but perception.
It's not always legal. Maybe it's just not the right thing to do. I don't know. I think that it is, if we go back to that idea of status of the speaker, I do think actually that rank and grade, there are differences. There are certainly differences in what sort of political practice we're able to have. If I have stripes on my sleeve, I can run for certain offices, like school board. If I've got this, I can't. There are differences, and differences that we make very clear about political speech. And I think the same can be said for religious speech as well. Yes, sir?
I have a question on your thoughts, specifically during holiday lighting schemes. Just fleets in port do this on ships.
Good.
The holiday,
And what do they do? Tell me, what does it look like?
they string up Christmas lights,
Okay.
either from the up and overs or Santa Claus on the deck.
You're
Trees, Santa Claus. I mean, it varies with each ship.
And all of those, the Supreme Court would say, are secular symbols, non-religious symbols. The Supreme Court's even said that Christmas trees have nothing to do with religion. That when someone looks at a Christmas tree, they don't think of the creche and they don't think of the birth of Jesus Christ. They think of presents and Santa. Now, you can disagree with them, but that's what they've said, that the Christmas tree in America has become a secular symbol. How can I make it one that is not? What could I hang on the Christmas tree? If I hang angels and crosses and creches, I might have converted that into a religious symbol. So here what I'm saying, I'm not saying the wing commander or your post commander can't hang up lights or have a Christmas tree. But if we start to merge from there into having the blow-ups of Mary and Joseph, that may be crossing a line. Now here's a tough one, or at least a little more challenging. Personal government workspace. Whose is it? Is it mine? Is it the government's? And I'd like to illustrate this with an example, and this is true. There was an instructor at the Air Force Academy. He was civilian. There's this thing, wonderful thing, called extra instruction. You can go, you can ask questions, you get help. And he had 3 baskets on the way out. And on the way out, he told cadets to pick one. You could pick the pocket cross, you could pick the prayer card, and although he didn't call it this, I call it the basket of atheist candy. What is he doing with his personal government workspace? He's proselytizing, but doesn't he have free exercise? You can have your IP points if you take it out of the right basket. There's some things that we're allowed to do in our personal government workspace, and there's probably some things that we're not. It's hard to talk about it in a religious context because people have very firm convictions about religion. So let's put it in something that's not controversial. Baseball. You come to me for a will. You're going to go get deployed. You want your children taken care of. And I tell you, okay, I'll do your will, but your next child, you have to name him Fenway. Can I do that? No, says the Yankees fan. This, I think, is easier to understand if we get it out of the religious context and back into our joint ethics regulation. We talk about the use of government resources and the use of government workspace in ways that are not controversial. We do it all the time. It tells me that I'm not allowed to sell my daughter's Girl Scout cookies in the office because it's not appropriate. Do I know it happens? Yes. It doesn't happen in my legal office. It's the same idea that if we are using our place, if you're in the dentist chair and the airman or the sailor says, I'll use the stuff that won't hurt as bad, but you have to convert to my way of thinking or my religion, we'd probably say that's a foul. And the same idea can be used as we think about religious speech and religious displays. Take it out of religion for a second and see if it makes as much sense. And I told you we'd also hit this. This is accommodation. These are two officers, doctors in the United States Army. They're Sikhs. Can they do that? At Walter Reed, they can now. We have accommodated, the United States Army has accommodated and allowed beards and turbans of people who are Sikhs while at Walter Reed, both indoor and out. I don't think they've allowed those, but I don't know. But I had a client, I was a defense counsel, and I had a client, and she showed up, she was a dentist. She showed up at basic training, or officer training school, knife and fork school, and she had her hijab. Her recruiter in New York City had told her, yeah, she could wear it. And they said, you have to take that off. And she said, no. And they said, and you have to wear shorts when you go running. It is Maxwell and it's July. And she said, no, I'll wear sweatpants, thank you. And they discharged her from the Air Force. Why do we do that and allow this? Do we have to allow this? No. And in fact, so that's saying that that is recently okay. That was in October. The Supreme Court in Goldman actually took a look at this with respect to an Air Force officer who wanted to wear a yarmulke. And it went all the way to the Supreme Court, and the Supreme Court said the military can decide that in the interest of uniformity that they're not going to accommodate religious wear of uniforms. That we can have rules and requirements about how we look in the interest of unit cohesion. Congress didn't like that, and so they passed a law that basically read that as long as someone's religious head covering can be covered by headgear, it's okay. Who does that allow? Yarmulkes, not turbans. This isn't easy, and you are the ones who are going to have to make these decisions. We've got great DoD regulations out here that talk about balancing the interests of the military with the interests of the individual, of these sincere religious beliefs with mission readiness, mission accomplishment. What happens if have I done this before? What happens if everyone asks for this? Are there other means for someone to get to accomplish their same religious beliefs? I think we need to be careful in the area of accommodation because there is accommodation can go to a point at which I think it might have operational impacts. The Academy, the Air Force Academy, I think has almost gone overboard. There are cadets who believe that if anything conflicts with any holiday, regardless of how minor, that they don't have to take my test. And so we need to be careful. At the same time, we also need to accommodate. And we need to think in terms of accommodation, because I think it is better for our force if we do. These are tough issues, and they're not going to get easier. So have you read them all? Because now you get to apply them. There's a missile silo. You're the commander down in North Dakota, up in North Dakota, and a young captain comes to you and he says, "It is against my religious beliefs to be with a woman who is not my wife, and you have scheduled me with a woman on missile duty." True life. This happened. I want to be religiously accommodated. I do not ever want to be scheduled with a woman. Do you allow it? Why not? Good order and discipline, why not?
Isn't that the bird thing where it impacts the effectiveness of the military mission?
I think so. He said that it impacts our military mission. It impacts our effectiveness. He was given an art, sir. He was of a type of Catholicism, of a very conservative Catholicism. He certainly was able to support it based on his beliefs. And so it was a sincere, religiously held belief.
Would you not be able to argue that he knew the propensity that he would be assigned with someone else?
I think you certainly could. I think he probably knew that at some point in his career he might be assigned with a woman. I would encourage you as commanders, and this isn't just going to happen when you're a wing commander, because last year we had a similar incident in the Air Force where we had a co-pilot who wouldn't listen to a woman pilot, and they almost had a safety incident because he wouldn't take orders from her to clear certain things, and he wouldn't make the appropriate call signs and responses. They had known about that. His peers had known about that, and it almost ended up in an aircraft mishap because they let it go on too long. All right, well, that was easy, so let's go to another one. Gays in the military. Now someone comes and says, "I refuse to be on that submarine. I refuse to go to sea with him. It's against my religion. It's against my moral principles. I won't do it." Same argument? Did the contract change for the officer who had the women?
Well, I mean, I don't know. Nuclear weapons have been around a long time. So,
It's true.
I mean, when did women get integrated into nuclear ballistic service? So, if it happened at that time, maybe he's got a case. He can say, "Hey, I don't want to do this anymore."
Do you want to let people out of their enlistment just because they don't like the way rules have changed? Does that have some ethical consequences? Sir?
One comment is that when it comes to accommodation, really the test is, can I accommodate that person if they have legitimate beliefs at this time, at this command? And even in your first example, to look beyond and say whether someone might have problems down the road is not the proper time for accommodation. If you've got a command of 1,000 people and there's only one woman, in that first scenario, you
think absolutely, your point about that it's situation dependent is a very good one. I think as a commander, you're going to have to decide, even if I only have the one example and I could give the accommodation, is this good for my unit to accommodate beliefs that I don't have to get along or work with others? And that's a commander's decision. Sir?
And of course, the issue is now you're setting precedent.
Yes.
So,
Yes.
And can you universally apply that decision?
And I think, especially in this bottom, the only example that I have been able to, in my own mind, in thinking through accommodation, and are there any particular career fields that we may give accommodation for in the idea of integrating homosexuals, open homosexuals? I think actually maybe in the chaplaincy. Based on some statutory provisions, we can't force chaplains to pray or do things that are against their faith traditions. And so I won't be able to force a chaplain to have to preside over a gay marriage. Because that may or may, if that violates his or her faith beliefs. But I can force a chaplain, I believe, even under accommodation, to still provide and be a chaplain for all the troops. And I think that most chaplains, and you're very fortunate to have chaplains in your organization here at Naval War College who would attest to that as well. So, not easy. There's a lot of murky areas. There's problems. Lawyers love conservative advice. And when I talk to JAG groups, I tell them they can't do that here. Because if you're too conservative with your advice, you're going to bump up against one or the other of the clauses. But as much as context is the key, I think it's important that when we're looking at these issues, to provide our best advice, to think about some of why there is those tensions. Why do we have these differing rules? Because it's not only our operational effectiveness that is tied to it, but it's also the constitutional rights of our members. With that, I'd love to entertain some questions. And I've been told to look for student questions too. Sir.
Lieutenant Commander Hilton, I was kind of expecting you to answer this at the beginning, but I didn't hear it. The Bill of Rights says that Congress shall make no law for establishment, not any government agent. How do they reconcile that?
Good. It's been interpreted as any government agency. So good question. But every court in the land has ruled that it's not just Congress that we're worried about, it's any government actor. And so the question becomes, when am I acting like a government actor? And when am I acting in my private capacity? But that has been ruled to be beyond just Congress. Good question. Sir?
Can you tell me how the law defines religion?
Well, that's a good question. It defines it as a faith-based belief, but it's not as strict as one might expect. And I don't know if I have any of the actual language on me to give you an actual definition. But the court has not required any sort of belonging to an organization. So I don't necessarily have to have some sort of practice group with thousands of members. It can be just a firmly rooted faith belief as a religious practice. So, absolutely. In the back.
Lieutenant Commander De Pena, all these accommodations, don't they provide some type of privilege? I mean, all of us, many of us, share the burden of going to the front lines combat. Well, I'm not going to this patrol because this is my day to save. I'm not going to take that duty because at that time exactly I'm going to be praying. Sorry, I cannot go to the front ward because I'm sick. I'm allowed to wear a beard, so I cannot wear a mask. I cannot go to the front lines. How do we level the field where the accommodations do not actually provide privileges that then put the burden on us, where their constitutional rights actually violate our constitutional rights, our privilege and responsibilities?
Absolutely, and I think we touched upon that yesterday with the idea of privileges and power and how do we reconcile the two. I think for starters, I think at least, and I'm going to take aside deployments for a moment and come back to stateside. For starters, a recognition that we have built-in accommodation for the masses. We have what at the Academy, the Air Force Academy for inspections? What are they called? Steve? SAMIs. What do they stand for? Saturday? They're not Sunday morning inspections? No, they're Saturday inspections. Why? Because everyone went to church on Sunday. We had built-in accommodation for those of the Christian belief. So first start with, especially stateside, the recognition of, oh, here come these minority faith groups again, coming to ask for some sort of accommodation. Well, what are we already providing accommodation for as a rule for military folks who are of majority faith groups? Now, that said, I think as commanders, we have to take a look at making sure that that there's a balance between accommodation requests and mission accomplishment. We don't get to just get out of patrols when everyone else is pulling them. And that becomes the balance that commanders have in maintaining the good order and discipline of their units and trying to make sure that we've got equal distributions of assignments, that everyone's pulling their own weight. Do I need to give the person who has absolutely no faith group some time off just to watch a movie? What about it? I like to look at it, we'll pull it out of the religious context. What do we do when we start looking at deployments and we always pick on the person who is, I heard it, the single guys? Are we doing them a favor by always sending them? So we can take this out of the religious context and manage our forces and our accommodation requests so that we're providing equities across the force. Another question. Sir.
It seems to me that the government has been promoting religion for the length of its existence. We build chapels at the academies, we have a chaplain corps, the Congress has a designated chaplain. God we trust is. Can it not be argued, however, that for the military, that beyond good order and discipline, there is the issue of unit cohesion and effectiveness in battle? And it seems to me in the last 30 years, the Supreme Court has increasingly allowed divorce of the military from other requirements and standards and pulled back from its interference in military activity. Is this reading correct of how you can justify much of religious practice in the military on the basis of unit effectiveness?
I'm not so sure if it would be as much of unit effectiveness as preserving the constitutional free exercise. And in looking at the legality of the chaplaincy and as the chaplain corps, what courts have said is, well, we take our troops to places that they may or may not be able to practice or to attend a worship service of his or her choice. And therefore, by having the chaplain corps, by having churches and synagogues and mosques within our building structures, that we are promoting the free exercise of our military. And not saying, well, you got to check that free exercise card when you come in the doors. And so I think it's probably more akin to the free exercise aspect. In response to that, I'm often asked, it kind of leads me down a segue of asked a question or an opinion on, is this permissible? Well, can I do this or can I do that? And it's always framed in the context of how far can I go in discussing what I want to believe or what I believe, as opposed to looking at our very diverse and pluralistic military and taking a look at changing that question to what's the right thing for my unit? What's the right thing from an ethical course of action and from the good order and discipline of my troops? And I think in framing our mindset of is this good, and understanding that we have so many faith groups, and are we capitalizing on everyone's strengths if we exclude or make decisions that exclude those faith groups? So I think it's important to look at good order and discipline, but I think when the court upholds things, they're looking more at the free exercise clause. I don't know if that answered your question, sir. Sir?
Yeah, Mike Slane, Navy retired, and I'd like to thank you, first of all, for just a great discussion. Recently I read, and I can't remember where I read this, that the ACLU or some other organization was litigating to remove crosses from national cemeteries. I just wanted to, is there truth to that, or has it already been adjudicated?
It's actually, the case went to the Supreme Court in October, and it was argued, I believe, in the October timeframe. And interestingly, us constitutional law geeks, that would be me, were really excited about this case and about what it might be. And the long and short of it is that Congress eventually ceded that little bit of land to a private company, and everything became, the discussion at the Supreme Court veered away from the religion clauses and started doing arcane things like standing and things that only excite lawyers. And so they are not going to answer the question, but I expect almost every year on the docket, the Supreme Court has, in one way or another, a religious type of case. So it will come up again, but that case in particular is not going to be the great religious case that we had hoped. So, well, I'd like to leave you with this. I know we talked about the rifle sights. There is a Lieutenant Colonel, Benjamin Bush. Some of you may recognize him because he's in the reserves, and he's also on some various TV shows when he's not pulling Marine duty. But he gave an interesting essay, verbal essay on NPR, and in talking about these rifle sights. And he said, by brandishing weapons with Christian messages, there is a deep and ugly blending of religion, politics, and bloodshed, and it has unwittingly painted our government and our military with the embarrassing language of crusade. But I did not go onward as a Christian soldier. I went forth as an American and as a Marine, and I would hope that we would be able to say that we're going forth as soldiers, as sailors, and as airmen, and that is the reason we're going to do what our country's asked us to do. And we keep these principles and this tension in mind as we face these not so easy choices as our careers progress. Thank you all very much, and have a great day.
Thank you, Major Letendre, for a truly spectacular presentation. I want to add just one thing. Linell and I were both at the Air Force Academy when the religious controversies were coming down, and she touched on this, but I want to emphasize it. There was an odd mood in some quarters at the Academy that I called it religion limbo. How low can I go? I mean, what can I get away with? And it struck me that this is exactly the wrong attitude, that the right attitude for any commander is, given that I have a diverse group of people that I have to lead, am I going to do anything that's going to make some of them feel somewhat excluded from this unit? And insofar as anyone does something like that, it seems the fundamental ethical failure is not governed by what can I legally get away with. It's how should I understand myself as a leader of a unit or an organization. So I would encourage people to think about reframing it as in terms of just what are the legal boundaries and how do I stay just barely within them. So thank you very much. Enjoy your lunch, and we'll see you after lunch.